Good morning. My name is Roy Breitenbach, and I am presenting this webinar today on behalf of the Fairfield County Medical Association. I'd like to thank the Fairfield County Medical Association for allowing us to provide this program, which we think is going to have some useful information regarding how to deal with disability issues in a medical practice. So once again, I thank Mark Thompson and the leadership of FCMA for allowing us this opportunity. As I said, the title of this webinar is Practical Advice for Resolving Difficult Patient and Employee Disability Issues in a Medical Practice. And my name is Roy Breitenbach. I'm a partner director here at Garfunkel Wild. I practice in both Connecticut and New York. And one of my areas in which I've specialized over my career for the last approximately 25 years is helping healthcare providers resolve disability disputes, whether they be brought by a patient or brought by an employee. And this webinar is going to talk about both patient and employee disability issues. The first part of the webinar will talk about patient issues, and then we'll go into disability issues with regard to employees. So let's go now to a kind of more detailed overview of what we're going to discuss. First, we're going to discuss the obligations of healthcare providers to ensure that patients who are disabled have access to their facilities and services. We'll talk about what changes in policies and procedures healthcare providers may have to make in order to ensure that their services are accessible. We'll then talk about auxiliary aids and services that providers may have to offer in order to make their services accessible. Then we'll also talk about some policy, procedure, and training, as well as making your physical premises accessible to patients or other persons who are disabled, and making your websites accessible to persons who are disabled. And that will talk about the first part. These topics will be the first part of our webinar, which is dealing with patient access. The second part of our webinar will talk about employee issues. So let's now go into the law that kind of governs all of this, and that is the Americans with Disabilities Act. The Americans with Disabilities Act was enacted in 1990. It basically has three different titles. Title I is discrimination in employment. Title II is discrimination by governmental entities. And Title III is discrimination by public accommodations. Your healthcare practices obligations to provide disability access to patients is governed by Title III of the Americans with Disabilities Act, unless it's a municipal or a state hospital, in which case it will be governed by Title II. Title I deals with discrimination in employment. And I have a tagline here: don't forget the New York State human rights law, but it'll be equally applicable to, say, Connecticut. Do not forget the Connecticut Human Rights and Opportunity Law. Most states, New York and Connecticut, for example, two of them have their own laws that prevent disability discrimination, both in the context of employment and in the context of patient access. Fortunately, for those of us in Connecticut, the Connecticut statute is very similar to the ADA, so if you follow what I'm talking about with regard to the ADA, you will also be complying with the Connecticut statute. So let's talk generally about the obligations concerning disabled patients. What's unique about the Americans with Disability Act is that the Americans with Disability Act governs affirmative conduct. Prior to the passing of the Americans with Disability Act in the 1990s, discrimination statutes only prevented various persons subject to the statutes from doing something. For example, you couldn't make racial slurs. You couldn't treat racial minorities differently. You couldn't treat women differently than men. But it prohibited you from taking certain action. What's different about the Americans with Disabilities Act is that not only are you prohibited from taking certain type of action, but there's actually an affirmative requirement for you to do something for persons who have disabilities in order for them to enjoy the goods and services that your entity is offering. So let's go through kind of what the four main points are regarding practices obligations concerning disabled patients. It's illegal under the ADA for any business, building, or other place that's open to the public to discriminate against people with disabilities. That would include all medical practices, all hospitals, all healthcare facilities. As I've just said, Title III doesn't just prohibit discriminatory conduct, taking action, treating somebody differently because they're disabled. It also requires providers to undertake affirmative actions. These are called reasonable accommodations to eliminate barriers that prevent persons with disabilities from fully enjoying their services. So not only do you have to refrain from actively discriminating against a disabled person, but you also you may have to take certain measures called reasonable accommodations to ensure that they're treated equally. And what the ADA says is that if you're required to provide these reasonable accommodations and you do not, it constitutes or is defined as disability discrimination. So what are the types of reasonable accommodations under the law? Well, there's basically three with regard to patient access, and we'll talk about them. One, required changes to policies and procedures. Two, provision of auxiliary aids and services. Three, removal of architectural barriers. So let's first talk about required changes to policy and procedures. So the way this works is that if you as a practice have a policy or a procedure, and that policy or procedure is such that it doesn't allow a disabled person to access your premises, you may have to change that policy or procedure if it's reasonable in order to provide the disabled person with access. Classic example of this, there's two classic examples, companion animals, and then the second one is alternate intake procedures. We'll talk about companion animals in detail a little bit later, but basically the concept is most healthcare facilities have a blanket policy. No animals are allowed in the facility. It makes sense from an infection control standpoint. It makes sense from a management standpoint. You can't bring dogs or other animals into a facility. That's generally has historically been a policy in most healthcare facilities and most physician offices. However, if a person has a disability and uses a service animal, if the policy of the healthcare facility were to apply, that disabled person would be unable to access the healthcare provider services because they would need to bring their service animal into the facility to receive the services, but there's a blanket policy of the facility that prohibits the service animal from entering the facility. So what the Americans with Disabilities Act would do, it would say that the facility has to make a reasonable accommodation by changing its policy and procedure to allow service animals to accompany disabled persons in most circumstances when they're receiving healthcare services. So that's a change that is required to be made to a provider's blanket policies and procedures in order to make sure that there's compliance with the ADA. Another example would be altered intake procedures. For example, most physician offices require patients when they come in to fill out a questionnaire with basic health history information. There's a policy that information has to be filled out before the healthcare provider examines the patient. However, if a person is blind or has a disability that prevents them from writing or filling out the questions on the questionnaire, they can't comply with that policy and thus could not be able to receive healthcare services. The ADA would require that practice to change its policy and procedure and to create an exemption to this intake requirement for patients who, because of their disability, whether it be blindness or inability to write or whatever it is, are unable to fill out the intake form. So let's talk to the next category, which is the provision of auxiliary aids and services. So what the law says is that in order to provide equal access, a public accommodation, this includes healthcare practices, must provide auxiliary aids and services for people who are deaf or hard of hearing when needed. This is a very, very important concept. What the law says is that if you are deaf or blind, or you have some disability that prevents you from fully communicating about your medical treatment, condition, and prognosis, the healthcare provider has an obligation to provide you with some auxiliary aid and service, if it's reasonable, in order to enable you to communicate effectively with the healthcare provider staff about your medical treatment, condition, and prognosis. What the law does is it equates equal access to services to effective communication about medical condition, treatment, or prognosis. The concept is that every patient is entitled to effective communication about their medical condition, treatment, and prognosis. And if the only way, or the best way, that a patient can obtain that effective communication is through the use of an auxiliary aid or service, such as an interpreter, then the healthcare provider has the obligation to provide those services. Because the healthcare provider's obligation is always to provide equal access. Now, this is not a 24-hour-a-day, 7-day-a-week obligation, and this section is perhaps more relevant to hospitals, but not every time there's an interaction between a healthcare professional and a patient who is deaf, for example, does an interpreter have to be provided. Only those circumstances in which there's a significant medical interaction or significant communication going on, and we'll talk about that later on. So what constitutes auxiliary aids and services? Well, certainly would include qualified interpreters like sign language interpreters. In certain circumstances, depending on the person who is deaf, may also apply to note takers. And finally, may also apply to written materials. You may have to give more detailed written materials to persons who are deaf in order to communicate them than you would to hearing materials. You also may be required to provide some type of braille materials to patients who are blind. The type of auxiliary aid or service provided depends on what's needed for a specific situation. It also depends upon the nature of the person. Some people who are deaf, for example, don't know American Sign Language and can't use an interpreter. The appropriate auxiliary aid and service is dependent upon what is being communicated and how the deaf person communicates. It is a fact-specific, individualized, person-by-person inquiry. What the United States Department of Health and Human Services has always said is that it would be extremely difficult for the healthcare provider to demonstrate in certain service settings that effective communication is being provided in the absence of interpreters. So basically the presumption is, with regard to patients who are deaf, is that interpreting is often the most appropriate and reasonable accommodation that should be provided. A question always comes up in dealing with these types of cases is, if a patient requests an interpreter and the provider believes that there's another method that could also provide effective communication, does the provider have to honor the request for an interpreter? And that used to not be the case. It used to be the case that as long as the provider believes that the method that they're choosing to provide effective communication will provide that effective communication and actually does provide that effective communication, you didn't have to honor the patient's request. That's changed with the passage of the Affordable Care Act. Now, under the Affordable Care Act, there's a requirement for you to honor a patient's request regarding interpreting services unless the provider has a legitimate reason why it cannot or doesn't or believes another means of communication would be more appropriate. And that should be documented. So let's talk about qualified interpreters. Who are qualified interpreters? Well, qualified interpreters must be able to both express themselves, receptively and expressively. So both receive information and give information accurately and impartially using any necessary specialized vocabulary. So the interpreter has to be able to communicate using whatever medical terminology or other specific terminology is being used. An individual does not have to be certified to meet this standard, just has to be qualified given the unique circumstances. Indeed, there may be circumstances where a certified interpreter may not be a qualified interpreter if that certified interpreter is not familiar with the specialized vocabulary involved. Family members are not considered appropriate interpreters because of their emotional or personal involvement, and because they often have a difficult time to maintain confidentiality. As we've said previously, not every interaction that a healthcare provider has with a patient who is deaf requires the presence of an interpreter. Generally, though, what the government has said and what the cases have said, there are 4 different categories of interactions in which an interpreter should be provided in order to ensure effective communication if that patient uses an interpreter, typically. And that's discussing a patient's medical condition, symptoms, and history, reviewing, explaining, or obtaining informed consent, healthcare proxies, and DNR orders, explaining medications being prescribed, and dealing with complex billing and insurance issues. Briefly talking to you about sign language, you have to be sensitive to when you're ordering an interpreter is that there are multiple sign language systems out there. Not every deaf person knows American Sign Language. There are other sign language systems, and not all deaf people are fluent in sign language in general. When you have a deaf person who's coming to your facility or to your office, you have to understand what type of interpreter they require, what type of sign language they use. You have to make sure that when you provide the interpreter is able to understand and effectively communicate with the patient. This is a key point. There's also something called video remote interpreting, which is out there, which many healthcare practices use. Video remote interpreting is essentially a Skype-based or a FaceTime type system in which the interpreter is at a remote location, and via an iPad or a laptop, they have a visual and audio link with the location in which the patient is. And basically, the healthcare providers orally explain what's going on. The interpreter at the remote location receives this information through the audio link and then interprets that information via sign language, and then the video link sends that image to the patient who sees the interpreter using sign language on the iPad screen or the laptop screen. The federal government has said video remote interpreting is an acceptable alternative to live interpreters as long as there is high-speed internet access, so with sufficient bandwidth to ensure high-quality, clear, delay-free, full-motion video and high-quality audio there's a sufficiently large screen so the deaf person can see the signs accurately. There's trained personnel to set it up. There are some cons to using video remote interpreting. Many deaf patients don't like it, and in certain circumstances, such as if the patient has a limited ability to see the video screen, patient has limited ability to move his head, hands, or arms, excuse me, or patient has visual limitations, cognitive or consciousness issues, or pain issues, VRI may not be appropriate, at which point you should get a live interpreter. But notwithstanding those contraindications, there are many circumstances in which VRI is an appropriate alternative. It's frequently used in situations like urgent care centers and hospital settings in which there are not scheduled appointments. Where there are scheduled appointments, you can make sure and arrange to have an interpreter present for the scheduled appointment. If it's a situation where a patient just shows up in an emergency or urgent situation, many healthcare providers use VRI as a stopgap until a live interpreter can be obtained. Okay, let's talk about the removal of architectural barriers. So much like the provision of auxiliary aids and services, there's an obligation that healthcare practices have to remove architectural barriers that prevent patients with disabilities from fully accessing provider services. These could be, for example, doors that prevent wheelchair access, hallways that are too narrow, bathrooms that don't have handicap access, intake counters that are too high, not having acceptable medical equipment that enables transfer from a wheelchair, elevators that don't accommodate wheelchairs, buildings that don't have elevators. All of these are architectural barriers that in certain circumstances, practices have the obligation to remove or provide workarounds so that patients with disabilities have the ability to fully access the services. So let's talk about it a little bit more. And basically, if you're constructing a new facility or substantially renovating an older facility, you have to comply with the accessible guidelines issued by the United States Department of Justice. And those guidelines provide details about, heights of doorknobs, locations of handicapped bathrooms, widths of certain doors, all kinds of issues. They must be complied with. Additionally, regardless of when your premises were constructed, you always have the obligation to undertake readily achievable barrier removal. Typically, what that requires is to ensure an accessible path of travel from the front door of your premises to the exam rooms or the locations in which the patient is receiving treatment, and making sure that you have accessible medical equipment in at least the exam room to ensure that patients in wheelchairs can appropriately transfer and receive services. Another thing you would have to do is, which is readily achievable, is ensure that your intake desk, there's at least one part of the counter that's at wheelchair height. We're talking about all of these obligations. You will often hear about the concept of undue burden and danger to presents an undue risk of harm. There are concepts in the ADA that practices may not have to undertake certain policy changes, make certain architectural changes, or provide certain auxiliary agent services if it presents an undue burden to the facility. That was an out clause that was provided in the ADA to help small businesses that may be burdened about these types of alterations. The reality is, though, is that with regard to healthcare facilities, there are almost no circumstances in the 30 years since the ADA has been law in which healthcare providers have been able to slide out of ADA obligations on the basis of an undue burden or direct threat argument. So while there are those defenses, including the defense of you don't have to make a reasonable accommodation that fundamentally alters the nature of your services, it's difficult to conceive of a situation with providing interpreters, removing architectural barriers to have an accessible path to travel, changing policies and procedures in which these defenses will come into play. Okay, let's talk now about service animals, which is a huge, issue at many facilities. Okay. Under the ADA, a service animal is a dog that it's individually trained to perform tasks or do work for the benefit of a person with a disability. Under the ADA, no other animals qualify, with the possible exception of some miniature horses. Okay, Connecticut follows this same general rule. So there may be snakes that people say are service animals, there may be ferrets or whatever. They are not covered by the ADA or the Connecticut law, and you do not have an obligation to allow those animals into your facility. Only service animals who do tasks or work directly related to the person's disability. Those are the only animals that you have an obligation for. What's clear? There are no emotional support animals governed by this statute. Okay? Animals that are considered emotional support animals, which simply just provide a sense of safety, companionship, and comfort to those with psychiatric or emotional disabilities or conditions, are not governed by the ADA, and there is no obligation for healthcare providers to allow them into the facility. That's even though these animals may have wonderful therapeutic benefits, if they're not trained to perform specific tasks for their handlers, they're not service animals, and they're not allowed in the facility. You don't have to allow them into the facility. Okay. If the animal truly is a service dog, you must allow the service dog in all places of public accommodation to which the public is customarily invited or permitted. What this means for healthcare facilities is that you would have to let the service animal in the waiting room. If you allow people other than the patients to typically accompany a patient into an exam room, you have to allow the service animal in that exam room. If, for example, it's an ambulatory surgery facility, you frequently allow a visitor or a companion to come with the patient into the pre-op holding area, you have to allow the service animal into the pre-op holding area. Same thing with something like a recovery room. You probably don't have to allow the service animal into the operating room because you don't allow patient visitors to come into the operating room. Okay? You do not have to allow a service animal to remain if it poses a direct threat to the health or safety of others. For example, if the service dog is growling and lunging at other patients, and the patient who's the handler is unable to stop and control the dog, you could ask the dog to leave. Key question that always comes up about service animals, okay? What can you ask? This is an important concept because people have very different conceptions. There are really basically only two questions you can ask about a service dog. Is the dog a service animal required because of a disability? And what work or task has the service animal been trained to perform? Those are the only questions you can ask. Not whether they're certified, not asking them to show you the task, not asking the person what their disability is. Those are the only two questions that you can ask. What you can't ask is you can't ask about the person's disability, require medical documentation, require a special ID card or documentation, or require that the animal demonstrate its ability to perform the work or task. Okay. Going back just once to barrier removal, as we talked about, just to kind of sum up this area, With regard to barrier removal, there's three things that, regardless of when your facility is constructed, you need to make sure are accessible. There's accessible path to travel, that there's accessible signage, and that there's accessible medical equipment. Okay. Now let's talk a little bit about minimizing the risk. Gave you a lot of materials about your obligations, and there's a lot of pitfalls here, and practices all the time are being sued for failing to accommodate, whether that's brought by private plaintiffs or governmental agencies. These suits are expensive to defend, often come equipped with negative publicity, and cost a lot of money in settlements, potential jury verdicts, continuing injunctive relief, and they're just generally very problematic. So how do you minimize the risk? Well, you minimize the risk by making sure you have effective policies, procedures, and training. You need to have a comprehensive policy on how to handle disability access. This is important because it's what the agencies look at when they're investigating your facility. Do you have a policy, a comprehensive policy about disability access? It also avoids the concept of deliberate indifference. Under the federal law, patients can only obtain money damages for violation of the disability access requirements if they could show that the facility is deliberately indifferent, that senior policymakers or senior decision makers at the providers or the facilities were aware that there was a potential violation, that patients were not getting disability access, and they deliberately chose not to deal with it. By having a comprehensive policy, you can make an argument that there's no deliberate indifference because you have a detailed policy in place. That policy has to have a point person, somebody on your staff who's knowledgeable about the policy, can handle and field questions, and can make sure the policy is properly implemented. A good comprehensive policy serves as a reference guide for your staff. The policy should cover the obligation to provide effective communication, how you identify a need for interpreters or other services, how do you request them, the selection and use of qualified interpreters, when VRI can be used, and a complaint mechanism. It's very important in this area that all staff is trained to provide an early identification of need. So, for example, with the first contact between an office, a medical office, and a patient, that's the best time to understand and appreciate that an interpreter is needed, so that you have time to schedule an appointment when there is an interpreter that can come. Early identification of need for a reasonable accommodation is key. Also key is documentation, making sure that all of your records properly document what aids, auxiliary aids or services, what accommodations were made, what were requested, what were done. Another effective procedure is to make sure that you have a good resource of qualified interpreters that you can call, and that when interpreters are coming in, you coordinate all healthcare services for the period of time in which you have an interpreter. And finally, follow-up, making sure that if you know that a patient needs a particular service because of their disability, then the next time that patient's scheduled for an appointment or a procedure, there's a flag in your computer system so that you know you have to provide that similar service in the future. Important to have training about this area. Using knowledgeable trainers that dispels myths about disabled people. For example, all deaf people can read lips. That's not the case. Many people believe that, and therefore, front desk personnel decides not to get an interpreter for a patient who may actually need it. The key people that need to have the training are the access points to your practice or facility, because they're the first point in contact, and they're typically the places where things go wrong. Training has to be as to what procedure is being followed for dealing with patients who are disabled, sensitivity to disability issues, the need to be quick in dealing with problems, and the need to document, refresh, and retrain. Let's talk now about the concept of website accessibility, which is a huge issue recently. In recent years, there have been a lot of cases that have been brought by plaintiffs' law firms contending that healthcare facilities and other entities are not making their websites accessible to people who are disabled. So, Title III, as we've talked about, concerns disability access for public accommodations. So the question is your website a public accommodation? If it is a public accommodation, then you have an obligation to make sure it's accessible to people who are disabled. The Department of Justice interprets Title III as obligating websites to be accessible to disabled. In the beginning of 2006, private litigants in the Department of Justice started filing or threatening to file legal action based on allegedly inaccessible websites. So it's pretty clear now that if you have a public-facing website, you have an obligation to make sure it's accessible to people who are disabled. If you don't, you can be investigated by the government, you can be sued by private attorneys, which lead to compensatory damages, fines, and injunctive relief. Private lawsuits are becoming rampant. There are plaintiffs' law firms that are bringing hundreds of these cases in federal courts every month. If you're sued, you face the possibility of compensatory damages, costs for repairing, making your website accessible, paying plaintiffs' attorney's fees, and dealing with negative publicity. So the question is, how do you make your website accessible to people with disabilities? Well, the United States Department of Health and Human Services strongly suggests that everybody use the Web Content Accessibility Guidelines 2.0 AA. These guidelines apply to federal websites. The federal government uses it in its settlement agreements, and the Department of Health and Human Services acknowledges that standard. So your IT personnel should make sure that your website complies with these accessibility guidelines. There are programs you can buy, commercially available programs, that look at your website and determine whether or not it complies with these accessibility guidelines. These standards are internationally recognized and uniformly recognized. And as I said, there are programs out there that you can run against your website to make sure that your website meets these standards. Here are some of the basic principles behind the standards. Basically, if you have non-text content on your website, video, images, there has to be some text alternative so that it can be changed into other forms people need. For example, blind people typically access websites by using a program that crawls across the website and converts whatever information is on that website into speech for the blind person. The only way you can do that with images is if there's alternate text behind the image. So your website needs to have alternative text behind the image in order for these web crawler programs to work. Likewise, if you have a video posted on your website, in order to make it accessible to people who are deaf, the video should be closed caption. You may have to use symbols or simpler language to deal with people who have some cognitive disability. You may need to provide alternatives for time-based media, pressing a button, doing something within a certain period of time before it times out, because if people have a mobility disability, it may be difficult for them to complete the task within the time allotted, and they'll continually be timed out. You may have to create content that can be presented in different ways. For example, simpler layout, different colors, so that it makes it accessible to people who may have some visual issues. Other principles include making all functionality available from a keyboard, because certain people with mobility disabilities can't use a mouse. Provide users enough time to read and use content. Don't design content in a way that is known to cause seizures, such as by using blinking lights. Make what text content readable and understandable. These are all things that the WCAG principles apply. So how do you do all this? Well, first of all, you identify the publicly accessible parts of your website. You may also have to determine whether, because of employees that you have, you may have to make employee accessible access, disability access to your website. Then you should do an internal assessment of what is and what is not in compliance with the standard. Make appropriate changes to bring the website in compliance, guided by IT professionals. Undertake continued audits and other compliance checks, because as you add content to your website, a compliant website may become non-compliant. And ask for feedback from disabled people as to how they're navigating your website. Let's talk now about disability discrimination in employment. Title I of the Americans with Disabilities Act prohibit employment decisions based on a disability. Like Title III, there's a reasonable accommodation requirement. If an adverse employment decision is connected to a disability, then the employer had to consider a reasonable accommodation. Okay, so if you're terminating an employee for failing to do something, and if that employee didn't do that thing because they were disabled, and there was a reasonable accommodation available that could have allowed an employee to satisfy your requirement, then you're guilty of disability discrimination if you don't provide the reasonable accommodation. Similarly, if you have rules or policies that employees must follow, there are circumstances in which you may have to alter those rules as a reasonable accommodation for a person who is disabled. Who's disabled under the statute? Well, it's a wide range of people. If you have a physical, mental, or medical impairment resulting from anatomical, physiological, genetic, or neurological conditions that prevents the exercise of a normally bodily function. People who are alcohol and drug abusers may also be considered to be disabled. The obligation to provide reasonable accommodations is to the known disabilities of an employee. Okay? You have to take actions which permit an actual or prospective employee with a disability to perform in a reasonable manner the activities involved in the job. If the employee still cannot fulfill essential job requirements with the reasonable accommodation, then there's no employment discrimination. So how does this work? Well, basically it's this. If, for example, you have an employee who has a mobility disability and works in data entry, you have a policy that prohibits employees working from home. The employee may want to work from home for 1 or 2 days a week to accommodate their mobility disability. You, as an employer, might have an obligation to reasonably accommodate that employee by allowing them to work home for 1 or 2 days a week, as long as they can still get their job done from home. So that you have to look at the job description of their job and whether or not physical presence in the office was absolutely required for that job. If it is, then a reasonable accommodation of allowing them to work at home, it does not apply. That's not a reasonable accommodation. It would fundamentally alter the nature of the job, and the employer doesn't have to provide it. But if a person is acting as a data entry person, and there's no legitimate reason why they have to be in the office to perform this job, you as an employer may have an obligation to make a reasonable accommodation by allowing them from working from home. When there's a situation with an employee, the employer, with regard to disability, the employer has an obligation to engage in an interactive process with the employee about what potential reasonable accommodations may exist. You're not obligated to provide an accommodation if it imposes an undue burden. You don't have to create a position that doesn't exist for a disabled person. You don't have to alter essential job requirements. You do have to make changes in policies that are reasonable and wouldn't fundamentally alter the nature of your goods and services. You may, for example, have to alter time-off policies. A person who is disabled may have to require a reasonable accommodation of additional sick time to accommodate their disability. And again, like everything else, policy, procedure, and training is what's required in this area. There's a major need to have good documentation. Supervisors are trained how to deal with requests for reasonable accommodations. Having a good set of employment policies is key, and be careful and proactive about engaging in the interactive process. So that's basically the presentation. Tried to get it in under an hour. Went through a lot of information. My contact information is here. If anybody has any, I'll take a few questions now. If anybody has any questions, it looks like that there aren't any questions, so that's fine. But if anyone can think of any questions at a later date, please feel free to email me, and I'd be happy to answer whatever questions anybody has. We have a wealth of knowledge in this area and pretty much know about every situation, both on the public access and employment side that may come up. So I'd be happy to speak with anybody with any questions. Thank you very much.